I'd said when I put the jacket on that I am comporting myself in a manner I would expect to be held accountable for under consideration of professionalism, and that could also include if I was filing a professional grievance against a colleague, up to and including a superior, and or up to and including somebody that would be slammed with me, if you know what I mean, and or somebody that might at some point in time have to take an order from me, right? It's 1:45 p.m. on December 13th, 2020. Something happened on Friday that was different than anything that's happened before, and when I awoke on Saturday morning, it was more significant and severe than anything I had experienced before. And I've been tracking, understanding something got swapped in a very, very significant manner. And I'm not going to be mean or cruel as much as I can avoid it toward what happened, but it is a effort to invoke a sort of spiritual drawdown. And these are very, very important matters to distinguish from actual policy implementation or rights to due process under a constitutional system. And I'm aware of that. I found some public comment periods available on the Federal Reserve site in October. And I was doing specific kind of research, and I was very concerned about what I'd seen, specifically the timelines for which the public comment period would close, and how they actually appeared to revisit issues that had already been brought up through public comment periods, but it was as if they were trying to recalibrate timelines that might have been associated with those previous public comment periods as a form of economic engineering, as opposed to a form of due diligence in regards to the required public comment period concerning changes to federal policy. So I made a voice recording at the time, extemporaneously, and then on November 3rd, I transcribed them. I wrote them out, and the understanding was I was going to make a written record of them on the 3rd, as a way to try to, channel my energy and my currency. And then the understanding was that at later times I would submit them for actual publication. On November 11th, I submitted to the Federal Reserve a public comment for R-1726, which had to do with convertible virtual currencies. I submitted it and I indicated the information. There were three typos and the final version. Even though, as I wrote it, I did the best I could to make sure I didn't include any typos. But when I copied it from what I submitted to the Federal Reserve site, then there were three typos. And those three typos were an inherent strategy. And I understood it as such. Now, I've been waiting for it to be published. And I put in the public comment, the number of public comments that were up at the time. This was during a time frame when I understand the Supreme Court was considering a case around the Affordable Care Act. Now, for a considerable amount of time, they have not published my public comment, but they've published others. And for a certain amount of time, including when this transition or rather swap out has been happening, there have been 44 public comments under this number. I am concerned that they allowed a manipulation of Federal Reserve policy in order to tear the public comments to appear as if there were only 44 public comments submitted so that it can be used as a unofficial or non-legal tender currency to run black ops in connection with somebody's nuclear paradigm that is not actually the actual head of state and is somebody that is potentially operating outside of any constitutional authority. Now, there may be other reasons why the Federal Reserve decided to do this. It may, in fact, be involved in some sort of proceeding internally where they are investigating criminal activity, including at very high levels. But I've been watching for over almost 2 years now, specifically in connection with the Federal Reserve. There is a form of economic engineering that has been going on that is not only unconstitutional, but constitutes seriously high crimes And the question becomes, well, under what authority are they in a situation where they believe they are authorized for this level of political and economic engineering? They're engineering entire national economies of other countries while refusing to do things domestically that would provide the kind of support we need in this country. Part of that is actually about acknowledging and valuing the citizen participation. We are the people. Congress, the president, even the Supreme Court gets their authority from us. Our attention paid to policy and our reflection on its implementation and our criticism is actually a form of currency. As a matter of fact, I've already acknowledged just this past summer in a very key matter that I was investigating. Somebody else had provided a public comment specifically to the Federal Reserve years ago that's absolutely essential for consideration right now. If that had been acknowledged as a legal tender currency, and things comparable to that had been acknowledged as a legal tender currency, we would not be in a situation where we're considering ourselves as somehow being bankrupt and or in a position to be leaned upon so that we can be used as assets of the national economies of foreign countries, including ones that may be legitimately or are, as I have alleged, for the most part, illegitimately identified as worthy of economic sanctions and also identified as an enemy of the state. So I'm going to read what I wrote as it is, which was submitted. This public comment comes after years of refusing to address how the role of cryptocurrencies is connected to chemical weapons development and disposal. This includes refusal to prosecute people, including members of the military who were complicit during their terms of service, as well as others after their retirement and classification as veterans, who cooperated with illicit activities as a substitute for actual acknowledgement of the role of chemical weapons in the invasion of Kuwait and the First Gulf War. This has aided and abetted a process of normalization efforts to compel cooperation with organized crime. Necessary support mechanisms to curtail potential infiltration of the government have been lacking, while we are exposed to intentional efforts to create bankruptcy in our efforts at appropriate administration. Crime masked as risk has been able to define this offloading and privatization of governmental functions as a means by which to legitimize warlordism as part of a long-term process. An audit of the United States Department of State from October 31st, 2019 revealed that for much of 2018 through 2019, there were no records of the source origin of transactions coming into the United States. This violated the Data Act, which had been implemented in 2014. Years had transpired in the course of which the Department of State refused to implement the measures necessary to be in compliance. Why did not the Treasury or the federal government intercede? This was the time frame in which cryptocurrencies were being set up for normalization both domestically and abroad. There are currently two major legislative tools that need to be considered regarding reporting, as would be referenced in this regard. 1. The Financial Institutions Reform, Recovery, and Enforcement Act of 1989, which mandated reporting on foreign-based transactions. And 2. Various aspects of laws connected to foreign origin money laundering, including the Anti-Terrorist and Effective Death Penalty Act of 1996. This needs to be considered in regards to the processes concerning the veto and then override connected to the 2016 Justice Against Sponsors of Foreign Terrorism Act, as well as actions that transpired on the executive level following its signing into law. The audit from the Department of State from 2019 said that there was also no information regarding provisions of payments to translators. This is important to consider because where a translator is working would determine matters connected to the tax base around which they are working. Insofar as the director of the Office of Management and Budget, Mick Mulvaney, was appointed at the beginning of 2019 to head a task force to consider the use of cryptocurrencies for the federal appropriations process, then taxation and its connection with the potential use of cryptocurrencies takes on another dimension. Taxation can provide people who use cryptocurrencies a potential means by which to track them in order to prevent against them being used in commission of financial or other crimes. To this time, there has been no official and public pronouncement on the results of the OMB task force. It is important to assess if a translator has legal residency or citizenship in a certain country, how to account for compensation based on local factors and local standards of living, as well as if and how transcripts, materials, or other factors they were working with may have different payment structures and would make a material difference in considerations of overall accounting. This can also pertain to concerns about depreciation of currency based on inadequate pairing that is especially problematic without an accurate accounting of equivalencies based on identification of source of origin. How do these forms of depreciation aid and abet other forms of currency devaluation and inordinately impact other factors that accrue as a default, liability, underfinancing, or underpayment? Refusing to expose this and hold it accountable lends to arguments that such practices are intentionally aimed at currency depreciation in order to undermine entities and operations for political purposes. This is not about actual financial capacity, but can also be used to aid and abet crime, including in manners that allow for artificial or contrived appreciative value to currencies that are illicit. A lack of accountability in these matters can permit a successful expropriation of the capital base of others to be attributed to those from whom they are not derived or from whom they do not originate, and hence justify tendencies to work toward normalization of criminal activity. This prevents an accurate and sustainable distribution of wealth, including regarding the information and knowledge bases of extemporaneous wealth creation. Appropriate attribution and accountability disincentivizes criminal and illicit activity and allows for the promulgation of the material conditions for rendering undesirable economic practices obsolete without sabotage or intentional catastrophization that can be used to leverage a cover-up of the culprits. Making a convertible virtual currency available for digitization as part of a crypto economy in terms of valuations and convertibility or exchangeability of the crypto economy has to do with the language within which the currency originated as well as how it was applied in translation. Things that mean one thing in English do not mean the same thing when translated into another language. This is relevant in consideration of applications that range from telemedication to electronic warfare. The manners in which particular vocal patterns or phrases are used in the crypto economy are how they elicit a psycho-emotional response. This response is going to determine someone's concept of attraction or repellence in terms of being a recipient or being able to access that currency. Additionally, the timing of this notice affirms my concerns regarding A, that no one in an official governmental capacity is going to deal with the material foundations for the development and rollout of the crypto economy. B, that numerous people were mischaracterized intentionally as disabled or some other form of troubled asset in order to be downgraded, depreciated, and or discounted, so other people could leverage their position to make it look like relativistically they were worth more or more successful than they actually were. And C, that it will actually address the facts that the crypto economy was based upon normalizing people to certain kinds of criminal behavior, i.e. resiliency, i.e. someone does something that is completely unacceptable based on a social norm or law, and then it becomes about how you respond or present as if you recover, even though there has been no process of restitution and there certainly has been no process by which a deterrent has been put into effect, i.e., no criminal prosecution for the crime in order to forestall or prevent for its reoccurrence, but rather that people's behavior is supposed to be modified in order to give the appearance of them not having had negative or deleterious reactions in the face of them being subjected to crime or being victimized by crime, i.e., no deterrent in the face of being attempted for enticement or extortion into cooperating with the crime. As they often do, it seems they are merely trying to change the naming association in order to try to make it seem like this is somehow acceptable, convertible virtual currency. It sounds so scientific, as if it were arrived at sterile, in a completely regulated, completely compliant manner, which is not at all what happened. Quote, or acts as a substitute for currency but lacks legal tender status, end quote. Now we got the actual instantiation of what COVID-19 is actually really about. We have the poll where you have somebody who is probably highly capable and highly qualified to do what they are actually doing, being illegally expropriated so that they can be extracted for someone else who provides the facade, including the aesthetic characteristics, that pleases whoever is actually able to encounter them. This is what that, quote, substitute for currency but lacks legal tender status, end quote, reveals, i.e., the more you can list it as being banned or black marketed, the more you can accrue percentage points as it being a black market commodity, the greater the leverageability. So instead now of talking just about disability, we could talk about things like being subjected to bans for refusing to cooperate with certain kinds of policies and procedures that are not just about issues connected to public safety or public welfare, but appear to be, as we have seen in the last year especially, but also in the last 5 years, about the appearances of performance without actually being required to demonstrate and authenticate it. The means have already been set up by which we've been able to normalize people to acceding that there is something legitimate about the crypto economy and that they should aspire to participate in it in a certain way. Now there's been a period of certain people being told or rendered into a sort of isolation or quarantine status, or a virtual kind of imprisonment status, under the auspices that they are somehow subject to some sort of reproachable violation for things that have not been explicitly prosecuted. What that ends up doing is degrading the actual value and the actual validity of the system of jurisprudence. We don't have the actual security we need in this country to back up what we're trying to do. In order to have the actual kind of security we in this country need, we have had to back it up with actual criminal convictions for things like racketeering, for things like massive securities fraud, for things like human trafficking, for things like money laundering, in order to finance acts of terrorism. We haven't done that. There are other countries that have, and instead what we've been trying to do is access as some form of political risk insurance efforts in other countries in order to cover up for criminal culprits in high places in this country, with an understanding that there will be some sort of bribe on a lower level offered to other people that go along with that cover-up, i.e., quote, substitute for currency but lacks legal tender status, end quote. It says, quote, the agency further proposes to clarify these rules to domestic and cross-border transactions that involve digital currency that have legal tender, end quote. What did I just say? Who gets allowed to have legal tender status? Why for 10 years have I not been allowed to have my name on a lease? Why is it that I am not allowed to even get my own starter credit card to rebuild my credit after I've demonstrated my own financial performance capabilities? Why did Congress get several years of their personal crypto economy set up and we were remanded to public comments at the Federal Reserve? It is important that at this time there are visible 18 public comments, with the one at the bottom of the list being from the Independent Bankers Association of Texas, and the rest only name individuals. Why? Why today? There is nothing legal tender about this. It's dated and timestamped 3:33 p.m. CST, November 11th, 2020. Now, as I was reading this, I'm aware that at one point, one of the clauses that had been originally written as a singular ended up getting pluraled, i.e., one of the IEs, that it was originally written as a singular. For some reason, as I was reading it, it became plural, as if there was more than one indicator, which at the time there was a singular. Now, as I'm reading it, it's coming through as plural. Other than that, it seems to comport as it was originally written. But when it was originally written, there was another frequency. I was co-frequency. Now that I understand this, I've seen patents on how this works. It's a technology that goes back a long time. It's something I've been trying to discuss for a long time. This understanding that somebody puts some sort of fluffy current on the top, when underneath there is a very dense transaction that is being carried along at another frequency, and those frequencies are actually working together. And I believe that what they've done is that's how they've comported and designed this crypto economy. And certain people are supposed to market a product and or talk about things in an abstracted manner, which actually literally draws on certain neurological processes, including things that are more abstract and or things that are visual in a certain manner, while other people that have access to a more comprehensive logic or computational capability are put on a denser, perhaps even lower frequency that is supposed to be unpacked or decoded but who's going to acknowledge? And so if you're allowed to be invisibilized and you're allowed to be disappeared because you have that highly analytical, critical thinking capability, and you're actually exposing crime, then they'll compress your data and have it function on a lower non-legal tender currency so that whoever's marketing that fluff product that looks really good and maybe even makes them feel better, especially if they're using it under some alleged telemedication, is going to also be transmitting all of that compressed data. And whoever has the tech at the other end gets to decompress it and then take what should have been used as evidence or should have been used as a report on pertinent national security or other kinds of safety related information, and then just take what they want, make a profile as they like, make a product as they like, and then give it to that person who's got the legal tender currency. And all of this is something that's been in development for a long time. And I understand and believe it has actually been intentionally used to destabilize entire national economies, including the American economy, and to also visit reprisal against political opposition. The question is, well, what kind of political opposition deserves this kind of reprisal? What are the crimes that they're trying to report? This is a very serious matter, especially today. Today is December 13th, 2020. Now, tomorrow I have an anniversary and a public comment that is about derivative agreements. It was the first time I made a public comment to the Federal Reserve. It was done in a particular manner at a particular time that, had it been heeded as being connected to a criminal investigation or as being concerns that were coming from somebody who had been trained in the nascent stages of inspection of industrial materials connected to infrastructure projects, up to and including infrastructure projects that would be public works upon which local municipal financing portfolios would be based. We'd have a completely different concept of what would be considered a virtual currency and or legal tender. But they never even published this public comment. And the anniversary for it came on Friday. Did somebody at the Federal Reserve actually get it and make it a secret currency for somebody else who thought that they were entitled to do what? Because what happened is they defaulted. And if they had not been allowed to claim what I had put into the public realm, which was intentionally done at the time it was done, hoping that it would meet some benchmark that would provide a bulwark for the safety of the people, then we'd be in a different position right now. But at the same time, if they had published it, then they would have had to have acknowledged that there were other things they did not do that they were supposed to do procedurally and supposed to do legally that would have prevented against the publication of that index tomorrow, wouldn't they?